Hello everybody, welcome to iExamBee's Legalbee. This is Amrita, your law faculty here at iExamBee. Embrace the iExamBee learning experience with us. And if you are preparing for any competitive exams after your law, then you are at the right place. Write to us an email on hello@iexambee.com if you have any queries and you require any guidance for competitive exam preparation. You can also call us on the number 920-5524028 and check out the online courses that are available on iExamBee's website. आप इन कोर्सेज के डेमो भी एक्टिवेट करके देख सकते हैं. Download our app for 50% faster job preparation and don't forget to subscribe to our YouTube channel Legalbee. I have started recently the 300 Important MCQ series, which is helpful for IBPS SO Law Officer exam and UIIC Legal Examination 2024. इन दोनों ही एग्जाम्स के कॉमन सब्जेक्ट्स भी मैं कवर करने वाली हूँ, जैसा मैंने आपको प्रीवियस वीडियोस में कहा था. सो टुडे आई विल बी स्टार्टिंग विद Arbitration and Conciliation Act, which is relevant for both the examination. If you have missed the previous videos of my series, then do check it out in the playlist of Legalbee. I'm going to cover every subject that is there in the syllabus of both the examinations, even the separate subjects that are there for UIIC and IBPS SO Law Officer exams. So stay tuned. Today we are going to start with Arbitration Conciliation Act important questions. What is ADR? Adverse dispute resolution, alternate dispute resolution, alternate diverse reactions, alternate disagreeing systems, adverse disagreeing resolutions. So the full form of ADR is alternate dispute resolution. It's basically talking about all the methods that come under ADR. It's not only arbitration and conciliation, but also negotiation and various other methods, even the settlements by Lok Adalat. All these are coming under the ADR mechanisms. And you can also read section 89 of section 89 of CPC for that. So the correct answer is alternate dispute resolution. These are the out-of-court settlement mechanisms. An oral arbitration agreement is deemed to be a recognized agreement at the discretion of the arbitrator. It is not recognized as an arbitration agreement. It may be recognized depending upon the facts and circumstances of the case. It is at the consent of the head of arbitral tribunal only in exceptional circumstances. It is at the implied consent of parties to arbitration proceedings. So oral arbitration agreement is deemed to be what? The correct answer is B. An arbitration agreement, and it shall be necessarily be in writing only, and an oral arbitration agreement is not considered as a valid arbitration agreement. So as the mandate is there that it should be in writing, so oral agreement is not an arbitration agreement. So the correct answer is B. Which of the following is not true regarding receipt of written communications that are made under arbitration? Any written communication deemed to have been received personally if it is sent on the mailing address. Communication deemed to have been received on the same day as it is delivered. Communication deemed to have been received if it is sent by judicial authority. B and C, none of the above. So which of the following is not true that has been asked regarding receipt of written communications under arbitration? Correct answer is C. As per Arbitration and Conciliation Act section 3, receipt of written communications. The communication deemed to have been received if sent by judicial authority. This is not so. So this is not true basically. If you will read receipt of written communications, clause A covers any written communication received if it is delivered to the addressee personally. If none of the places referred in clause A can be found after making reasonable inquiry, written communication is deemed to have been received if it is sent to the addressee's last known place of business, habitual residence, mailing address, or by registered letter, or by any other means providing a record of attempt to deliver it. Communication is deemed to have been received on the day it is so delivered. And this does not apply to written communication in respect of proceedings of any judicial authority. So this clause makes it very clear that option C, that is talking about communications deemed to have been received if it is sent by judicial authority. So that is something which is not true. Arbitral tribunal shall include sole arbitrator, minimum 3 arbitrators, minimum 2 arbitrators, any number of arbitrators, A and D, that is sole arbitrator and any number of arbitrators. So correct answer is E, as according to section 2 clause D, arbitral tribunal means a sole arbitrator or a panel of arbitrators of the Arbitration and Conciliation Act 1996. So correct answer over here is that it can have sole also, single person can also act as arbitrator, and there can be any number of arbitrators. The only thing is that they should not be even in number. International commercial arbitration is defined under Part 1 of arbitration, 2, 3, 4, none of the above, or whether it is not at all defined under the legislation. Correct answer is A, as per section 2 clause F. So in part 1 of Arbitration and Conciliation Act itself, it has been defined, and the correct answer over here is section 2 clause F. Basically here in this part 1 is the correct answer, that is option A. What is international commercial arbitration? It is disputes arising out of legal relationship. Same thing, arbitration on that, whether they are contractual or not, and they are considered as commercial. The only requirements are that they should be commercial disputes and one of the parties should be foreign over here. United Nations Commission on International Trade Law, that is UNICITRAL, has adopted dash on international commercial arbitration in 1985. UNICITRAL model law, UNICITRAL law, model law, arbitration model law, conciliation model law. It's about the source of the law. Correct answer is A, an act to consolidate and amend the law relating to domestic arbitration, international commercial arbitration and enforcement of foreign arbitral awards, as also to define the law relating to conciliation and for matters connected therewith or incidental thereto. So what has been adopted basically, as you can see in the preamble of the legislation, that it has adopted the UNICITRAL model law on international commercial arbitration 1985. As per part 1 of Arbitration and Conciliation Act, judicial intervention is permissible in case of arbitration, not permissible in case of arbitration, not preferable in case of arbitration, permissible only if it expressly provided under part 1, any of the above depending on facts and circumstances of the case. This is very important provision, I would say, very important question also, though it can be asked in some other ways as well, but judicial intervention, whether it is there or not in arbitration, that is something which is an area which is always asked and it's confusing at times. So don't be confused, be very clear with the concept. Answer is D, it is permissible only if expressly provided under part 1, as section 5 covers extent of judicial intervention. It makes it clear that notwithstanding anything contained in any law for the time being in force in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Arbitration agreement means intention of parties to carry out settlement, agreement by parties to submit to arbitration, reference of disputes by court along with parties to arbitration. A and B, all of the above. What is the meaning of arbitration agreement? Correct answer will be B, agreement by parties to submit to arbitration. Section 7, very important section, and I would say that you be very thoroughly prepared with this provision of that. An exchange of statements of claim and defense in which the existence of agreement is alleged by one party and not denied by the other. Above mentioned statement proves the existence of what? Arbitration agreement, intention of the parties to have a settlement, successful arbitration, chances of a compromise, success in arbitral award. Correct answer is A. It is actually the existence of arbitration agreement. This statement, exchange of statement of claim and defense, in which the existence of agreement is alleged by one party and not denied by the other. This is mentioned over here in section 7, as you can see, clause number C, clause 4, subclause C. That is talking about an arbitration agreement is deemed to be in writing basically. If it is contained in documents signed by parties, exchange of telex, letters, telegrams, telecommunication, electronic communication included, Exchange of statement of claim and defense in which the existence of agreement is alleged by one party and not denied by the other. So this can happen in before the court also. A party to arbitration proceedings may apply to the court for appointment of guardian for minor of arbitral proceedings at any stage of arbitral proceeding before commencement of enforcement of arbitral award, or during the arbitral proceedings only, after making of arbitral award, A and B, all of the above. So, a party to the proceeding may apply to the court for appointment of guardian for minor for arbitral proceedings at what stage basically? Correct answer is E, at any time, but before the enforcement of arbitral award. It is mentioned clearly under section 9, interim measures etc. by the court, when court can take interim measures, and same thing is there in section 17 also, where arbitral tribunal can take interim measures. So that application has to be made at any time, during proceedings, even after proceedings, but before the enforcement of the arbitral award. And that will take under section 36. The procedure is given for enforcement. An arbitral award has to be in writing but not necessarily signed. Writing and signed by the members of tribunal, can be oral also, A and B, A or B. Please note down A and B, A or B. There is a difference. So arbitral award, correct answer is B. It has to be in writing and signed by the members of the arbitral tribunal. As per section 31, form and contents of arbitral award, it is made very clear that it should be in writing, it should be signed by the members of the tribunal. Parties need not sign it. In case of conciliation, parties have to sign the settlement agreement. If mandatory procedure prescribed under the Act is not followed, arbitral award can be set aside. It is opposing public policy, then only it can be set aside. Both A and B are correct. Either A or B are correct. None of the above is correct. So if the mandatory procedure is provided under the Act, it is not followed, then what action can be taken? Both. Arbitral award can be set aside, and the award, if it is opposing public policy, then also it can be set aside. This is covered in detail under application for setting aside arbitral award. What recourse you can take against arbitral award, that is covered under section 34 of the Act. Please read this section also, as it is important, as it provides कि आप क्या grounds पे arbitral award के against जा सकते हो. Which of the following statement is incorrect? Arbitration agreement shall be in writing. Number of arbitrators appointment shall be in even number. Person of any nationality cannot be appointed as an arbitrator. All of the above, none of the above. So which of the following is incorrect has been asked over here. Correct answer is C. Person of any nationality cannot be appointed as an arbitrator. This is incorrect statement. Any nationality person can be appointed as an arbitrator unless it is otherwise agreed by the parties. So general rule is this. Section 11 clause 1 covers this. Power to rule on the jurisdiction of arbitrary tribunal rests with tribunal itself, arbitrator in case of sole arbitrator, civil court, high court, arbitration agreement. Arbitration agreement may specify that. So correct answer is A. As per section 16, competence of arbitral tribunal to rule on its own jurisdiction. Arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement, and for that purpose, arbitral tribunal can do this. Is covered under section 16. You can read this entire section. I have not provided the entire section over here, but that is covered under section 16. Relevant part I have taken over here. Conciliation involves communication between parties and conciliator, which has to be kept confidential, which has to be cultured, which needs unbiased approach, needs to be restricted at times. None of the above. Now, one question I have taken here from conciliation, though you may feel that why so less questions from conciliation, actually there are more questions from arbitration generally from this legislation. Many times you will observe that. Conciliation is a very short topic and easy also. So I would suggest you be thoroughly prepared. एक या दो question भी अगर आते हैं, it gets scoring for you. Conciliation involves communication between parties and conciliator, which has to be kept confidential, cultured, and all these options are there. Correct answer is A, that it has to be kept confidential. Section 75 covers this point, confidentiality. Confidentiality, it's a very important point over here in case of conciliation. conciliator is supposed to maintain that confidentiality. And उसने इधर का उधर नहीं करना चाहिए without the consent of the parties. That much he has to maintain. Even whatever happens in conciliation proceedings or the conciliation settlement agreement, which is the end result of it, that is also not allowed to be used in other judicial or arbitration proceedings. That's all from Arbitration Conciliation Act. Prepare 50% faster with us. In case of doubts and queries, reach out to us. Download our app from the Google Play Store and check out all the course features available even on our iExamines app. Thank you everybody. Have a good day.